actual bias has been proved. Let me pause there. So the judge went on to say, this is not even a case of reasonable apprehension of bias. It's actual bias for someone to sit when their family member is a party. If a case so scandalous, says the judge, succeeded in passing the scrutiny of the court, the standards hitherto applied by judging of such matters would have to be revised and the principles of natural justice modified. So if such a scandalous thing would be allowed to go, they say you'll have to change the rules of the law of natural justice. It's nothing less of scandalous. But if you don't see it, you don't see it. And then it says, the law draws no distinction between actual bias and real likelihood of bias. And I hold that this includes cases where a real likelihood of bias has been proved. As in my opinion, it is proved where a brother elects to be a judge in a competition for the grant of liquor license amongst a number of applicants, one of whom is his own brother. And then it says, amongst them are the spouses. Okay, here. Then there was some clever argument which was put there, which basically is fatal even in this case. So the lawyer there, Mr. Price, said, no, the only people who are excluded are spouses. Now here we're dealing with the spouse as it happens. But the judge even rejected that. It said, no, even if you are a brother, that's enough. And it says, amongst them are spouses to put it shortly, persons engaged in the intoxicating liquor trade in that matter. The intimacy of the married relationship may well give a spouse such an interest in the trade as will place him or her in much the same position as the actual trader who is disqualified by section for appointment. Hence, the general disqualification of a spouse, even for appointment. But the fathers, brothers, and other near relatives of traders are not at all in that position. It would be absurd to disqualify them for such, even such appointment. But it is by no means to give a court the power and so on. And then the court said, yeah, to basically rubbishing that argument of trying to distinguish the brother from a spouse. But the point I'm making is that even in that case, I'm also like you. My views are completely irrelevant. I might be annoyed by Mr. Milhem's insults, or I might not be annoyed. It doesn't matter. If I am annoyed, I'll sue him or do whatever I have to do if he wasn't protected by the privilege. But that's got nothing to do with it. I'm irrelevant in that. The issue is whether the public protector, in her position, will believe that somebody who has attacked in public on Twitter, her legal representative, whether she must expect that person to be assumed to be neutral. And that's just ridiculous. So it's not how annoyed I might be or whatever. That's my baby. It's got nothing to do with her. But anybody who is human must just put yourself in her shoes and say, what would you do? Let's assume this was a court case. There's a judge, and you argue in front of this judge. And then on the Sunday, when you are reading the Sunday Times, you hear that this judge has been insulting you. And then on Monday, you must go back to that judge. And they call that justice. Anyway, so those are the issues. And the committee, I mean, really, this committee, Mr. Ngola, I hope he is listening here. Even Mr. Ngola, of all people, said here, before when we did the application, members must refrain from attacking or involving themselves in anything to do with this case on social media for obvious reasons. And he was right. But when it came to voting, this committee voted that, no, there's nothing wrong with that. Let's go. There's no reason for recusal. Let's just proceed as if nothing has happened. You call that a reasonable committee. And Chair, you blame me when I say I know what's going to happen. If something like that can be seen by anyone to be okay, not even one word to say okay, it's not, anyway, it's fine. But anyway, the committee endorsed that and said it's all systems go, there's no problem. There's no problem about the spousal relationship. There's no problem about the non-disclosure. There's no problem about the tweets, says our committee. Anyway, that then takes us to the Pinochet case, Chair. The Pinochet case starts from page 50, and forgive me, Chair, I'm just going to read this because, again, I don't want to bore you with the facts, but for those who haven't read the case, this case happened with that dictator called Pinochet, who was a puppet of the West, like other leaders, and there was an issue about his extradition, and this guy had literally butchered anybody who knows the story of Pinochet. But anyway, Amnesty International was one of the bodies that was participating in the case. Now, there was a judge called Lord Hoffman in the House of Lords, and we should be proud because he's originally from here, but he rose in the ranks of that place to become a lord, and he has ties to South Africa. One of the bright people that are associated with this country, very bright. So Lord Hoffman, his wife, was involved with Amnesty International, and he himself was chairing one of the charities of Amnesty International. And then the case went on. I think there were 5 of the so-called lords who were sitting in this case. And then they made a decision. Pinochet, the dictator, then, unfortunately, these cases involve very vile people. Yeah.